Jim's our state's attorney, I didn't say that.
I'll pretend there's a podium. Yeah, this is unfortunately something I never thought I'd encounter in my 40-year career, that the legislature would pass a law that would give us the weakest criminal law in the country when we're dealing with a city like Chicago, which is the most violent city in the country. And if you want to know what the state's going to look like after this law goes into effect, just look at Chicago. And Bob Berlin and I joke that we have a Maginot Line. He has one between DuPage and Cook, and I've got one here. Now, we've had incursions from gang members from Chicago. Well, 90% of them are in the Will County Jail on high bonds, looking to be tried and then follow up with a sentence. In Chicago, 2,300 people are on ankle bracelets. I've got 630 in the Will County Jail, 2,300 on ankle bracelets, 75% of them violent. And I don't know if anybody saw the shooting in the Bolingbrook warehouse. There was one person killed, 2 people shot. That happened the day after somebody in Chicago on an ankle bracelet for murder. There's over 100 of those. Tracked down the eyewitness who witnessed his murder and murdered him. The next day, we have the shooting in Bolingbrook. Police do an excellent job. The offender is in the Will County Jail on a $5 million bond. So what does that do? What is bail for? Bail is to protect the public and the victims, witnesses, and to guarantee the appearance of the offender. That's going to be turned on its head if this bill goes into effect. Now, I'm very confident. I'm working on something that I'm hoping will bear fruit and stop it. I'll start with the thought that the Illinois Constitution guarantees that all persons shall be bailable. Well, that's in the Constitution. Now, you remember the variable tax rate bill that they tried to get through? Well, they had to get a 3/5 vote in both the House and the Senate and then put it on the ballot for us. And we were smart enough to realize that was a boondoggle, especially in light of what just happened in Washington. But there's no way that the votes are there to do that with the bail. This bill passed narrowly, and it passed in a 2-day cram session called the lame duck session, and it couldn't have been done if it wasn't for our wonderful friend Michael Madigan, because he had to okay that. So legislators had an 800-page bill dumped on their desk. Okay, figure it out. And it was covering all different subject areas. But the bottom line is, we're guaranteed the bail through our Constitution, both at the federal and state level. And so, when this thing was discussed, nobody mentioned what's going to happen to all the people in the jails. We have over 600 in our jail. DuPage, Lake, Kane, all have similar. So we're talking 4,000 to 5,000 people, and then I don't know how many are in the Cook County Jail because there's so many, 2,300 on ankle bracelets. There may not be anybody in there. So, but the bottom line is, that's just the beginning. And then once the inmates are out, we have about 1/3 of them that we can potentially ask for a hearing to detain them for no more than 90 days. If they demand trial, they have to be tried in 90 days. Now, that's the thing I'm going to be talking about, because speedy trial is 120, but this is a get out of jail 90 days. So every defendant, if this were to go into effect, would demand speedy trial on day 1. Now, my office, all my attorneys have over 100 open files. They continuously have over 100 felony files that they were working on. So if they were put under the gun, they had to start getting all these cases ready in 90 days. We couldn't do it. Plus, the crime lab doesn't turn things around in 90 days. We just tried an outlaw. He sat in jail for 5 years. Now, that wasn't our doing. He asked for continuances. A lot of times they'll do that for a number of strategic reasons. But this will change everything, where they've got nothing to lose by demanding trial on day 1, because I got to scramble like a maniac trying to get it ready. And if I announce ready on the 90th day, all they got to do is say, "Judge, we want a continuance." And then I just wasted 3 months running my brains out trying to get ready for trial, and now it's continued for how long, right? And then there's more cases that I'm getting hit with. So the bill defies common sense, and I can't even imagine the mindset that conceived this. It'll make it even worse in the city of Chicago than it is now. And let's look at the city of Chicago. New York has 3.25% more people than Chicago. Chicago last year had 485 murders, New York had 485 murders, Chicago had 800. And carjackings, New York had 511 for 8.8 million people. Chicago had 1,800 for 2.7 million people. Now that, we all think of New York as this ominous place, and we hear about these horrible things that happen on the subway, but they've got 8.8 million people and they have a fraction of the crime. So as bad as they say it is in New York, it's triple bad in Chicago. And this is only going to get worse. Now, when I mentioned the Maginot Line, every time we've got flock cameras. You've all heard of flock cameras?
Yes.
These things are truly amazing. And I've been using my drug forfeiture money to go out and try and help different agencies or cities, municipalities, whatever, to add flock cameras. And I've encouraged businesses to partner. That way we're drawing in the private sector to help protect ourselves. And then the businesses make their community safer, they make more money. It's a no-brainer. We just put in a camera out at Lewis University, and the day before there was a crime committed in Stager, and they caught the guy in the parking lot at Lewis with the flock camera. That's pretty crazy. The complete other side of the county. So this, the one thing I wanted to is this isn't a political issue. Bob Berlin and I were on the radio on Friday with 580 or 560, and with Dan Proft, because when you start getting partisan on something like this, you lose credibility, you lose traction. This is for the good of every single man, woman, and child in this state of Illinois. And Lori Lightfoot, on June 6th, for the first time, she broke ranks with the rest of the people up there. And you need to hear this. She talks about the residents in her community are also entitled to safety from dangerous people. She said the powers that be need to keep pressuring criminal court judges to lock up dangerous, violent people and not put them out on bail or electronic monitoring back into the very same communities where the brave souls who are mustering the courage to come forward and say, this is the person who is responsible. Now, the biggest problem that Chicago has with their violence is that in the black communities where the gangs are wreaking havoc, they only solve 20% of the murders. Why is that? Because people are terrified to come forward. They know they can't come forward. And so that's not the case in Will County now. But if I can't lock up the violent offenders, we'll have the same situation here. And then what will that lead to? That when criminals realize there's no boundaries, they get more brazen, they do even more crimes. And those people that tested the waters coming down here, we had a carjacking in Frankfurt. The 4 offenders are in the Will County Jail on a $1 million plus bond. We had a shooting in a subdivision near Wedgwood Golf Course with ghost guns. Both individuals are in the Will County Jail, been there since the shooting, and they'll be tried and processed. Every case that we've been involved in, and my favorite is the one we just won a motion on. There was a carjacking on Diversity Parkway in Chicago. The knucklehead did a U-turn and fled into Shorewood. We put out the tax strips, stopped the car, and he's in the Will County Jail on a $1 million bond. And the judge denied the motion to transfer it back to Chicago, where what would have happened if that had gone through? He'd be back out on the street carjacking. So, but this is so telling because Lori Lightfoot is part of the total Democratic machine that runs that area. She said this, letting these people out, that undermines safety. It tells the victims that there's no justice for them, and it undermines the legitimacy of the criminal courts. If we hold violent, dangerous people accountable, we will see a significant drop in the violence in our cities. But when you've got somebody who's accused of murder, attempt murder, rape, kidnapping, carjacking, as is now, these people are walking the streets right now today in our communities, because our criminal courts are not doing their jobs and taking into consideration the danger to the community. When somebody has a rap sheet as long as my arm and commits another act of violence, they are a danger to the community by definition and should be held pretrial. And I'll be talking to you about the fact that the rap sheet doesn't mean anything under this new law. No one is going to feel safe as long as those folks are back out on the street 24, 48 hours later after they go through the bond court. It's madness, and we know it is. She also talks about the fact that when individuals know that they aren't going to be held accountable, they become more bold and more brazen. Sorry. In this new statute, they codify 6 different types of crimes where we can actually ask the court to detain. The first one is a forcible felony with a mandatory prison sentence. And then but the last prong is we have to prove that they're a danger to a specific identifiable person. Well, when you murder somebody, that may be the only person that you're being a threat to. So the ultimate irony would be they would get out because of that. And then you do the flip side on an attempt murder. The person you were attempting to murder didn't die, they're still alive, so we will fulfill that requirement. This law is filled of nonsensical situations like that. Nonsensical shouldn't really be the word because of the danger involved, but this is what we're looking at. Then the next section deals with domestic battery. Well, domestic and aggravated domestic battery, but domestic battery is only a misdemeanor. So you could wind up detaining somebody on a misdemeanor, domestic battery, and someone who commits murder gets out. Again, that's disproportionate punishment. That could be a constitutional issue also. Orders of protection is another section. Stalking is another section, and we understand those types of cases. Then the gun crimes, and they list all the gun crimes, but then again, they come back to, we have to prove that the person's a danger to a specific identifiable person, which we will fail to do in many of these cases, and these gun crime individuals, who are the most dangerous in our society, will be continuously getting out. Then there's sex crimes, and they pretty much list the bulk of the sex crimes that we would expect. Now, in all of these cases, we have to bring a petition, and the longest that, like I said, that they can be held if they demand trial is only 90 days. Now, here's the kicker. When they get out, and they don't come back for their next court date, we can't get a warrant. All we can get is what's called a rule to show cause, which is a civil piece of paper that says, pretty please, will you come to court? Now, I can tell you the actual implementation here. The police aren't going to serve these. When a police officer is going after a violent offender with a warrant, he's cloaked in qualified immunity, he's got probable cause, and he can bring the SWAT team with him, and he can enter the house by force. If he's got this silly rule to show cause, he'll be going, Mr. Murder, would you please open the door? It's that ridiculous. And I work with the police, and they put their lives on the line every day for us. And I've had the immense privilege since 1992 of reviewing nearly every use of deadly force case by the police in this county. And I've not yet encountered one where the officers exceeded their lawful authority. In fact, in most cases, the police hesitate at the first opportunity to shoot and don't, because they're compassionate human beings, and they don't want to have to shoot someone. So, again, that's not what you see on TV. Will County is pretty much of a cross-section of the United States. Look at Homer Glen. You've got these gorgeous homes. You have a cross-section of the United States right here in Homer Glen. So it's not like we're an anomaly. So if that's the way the police are behaving here, it's the way they're behaving in most of the areas of this country. They take one case, one ridiculous case, broadcast it nationwide like it's going on everywhere, and it's not. It's an anomaly. This bill is a product of one of those cases. So that particular part will be literally the demise of our criminal justice system. Now let's look at the forcible felonies that are not mandatory prison, that I can't even bring a petition to detain. Burglary, robbery, vehicular hijacking, arson, forgery, kidnapping, criminal damage to property, second-degree murder, intimidation, hate crimes, aggravated battery, aggravated DUI, aggravated fleeing and eluding, drug offenses. If I arrest somebody with enough fentanyl to kill every citizen of the United States of America, and that's not that could happen. 2 milligrams will kill you. And I just pled somebody for 20 years on a fentanyl possession case. That person, from the time of arrest to the plea for 20 years, never set foot outside the jail. Because otherwise, if he's dealing heroin, every time he deals heroin or fentanyl or any combination thereof, every one of us is at risk. So I got Narcan for our drug dogs, because if they get it on their nose, it can kill them. So this is obviously not the kind of situation that any of us in this room ever thought we would be faced with. And then you add into the fact that without any attempt to detain them, they'll be given another court date, and if they don't show up, we can't get a warrant. Now we go to misdemeanors. Class B misdemeanors, Class C misdemeanors. Criminal trespass to land, that's something that recurs a lot for us, right, in our community. The police can't arrest. I don't know what they were thinking here, okay? So, and then it says, upon proper presentment of an ID, the officer is supposed to write out a summons for 21 days down the road. Well, then the officer leaves, the guy comes right back. You call, he comes out. Sir, you gotta leave. I mean, it'll be like Chinese, what do they call it? The chairs when you, yeah, I mean, it's ludicrous, but think about how once the people who like to break the law find out that nothing can happen to them, the numbers will grow. The Targets, the Walmarts, they'll let people all over the place, and they won't be able to do anything about it. Disorderly conduct, the same way. They can't be arrested. The only way to stop disorderly conduct and trespassing many times is through an arrest. This stuff, I've been looking at it, and to the point over the weekend I was reading the one section about how you do revocations and other things, and it's so poorly written. One thing you can't have in a criminal statute is ambiguity, or not knowing what exactly they're referring to when they're using a term, and it's just replete throughout this entire statute. So, the other thing is there's 2 sections where it says that simple failure to appear cured by an appearance cannot be used against the individual. So the person could not show up for court, there's a rule of show cause, and then they show up, and then they don't show up, and you get a rule of show cause, and they show up, and that could go on ad infinitum, and the judge is not allowed to use that to lock them up, which is clearly a violation of separation of powers. The legislature can't tell judges not to do their jobs and not to use their discretion. So, again, like I said, I'm working very hard to make sure that this doesn't get implemented. Like I said, I've been doing this since 1982. And I forgot to give this example. When Drew Peterson solicited a gangster disciple to murder me when he was in prison, if he had been out on the street, a free man, and done that, under this new law, he couldn't have been detained. Now, my family was my kids were little, my wife was very afraid. We had a couple of weird incidents where it sounded like a gunshot. The fire pit in the back fell over and broke, and my son came in, I just heard a gunshot! And my wife went crazy, and I looked out the window and I saw it was broken. And I said, calm down everybody, it's just the fire pit. My wife goes, maybe the hitman knocked it over. Okay, the paranoia. But the bottom line is, this is serious business, and we have to do everything when we write our laws, when we enforce our laws, to do everything we can to protect the safety of the law-abiding citizens in the community. And this is just something that I never thought I would see, but the way it was done, and I mentioned Madigan again, I mean, because really, as bad as some of the intent here, it could not have happened without him. He did not have to grant that lame duck session. He was trying to keep his power, and he lost it. And now look what he's left as a vestige to the rest of us. These criminal charges against him are nothing compared to what will happen if this law goes into effect. So all I can tell you is I'm working very hard on the constitutional aspect of it, and it's my intent that this not go into effect. So if anybody has any questions,
Jim?
yes.
When you were talking, I think everybody would want to know about the ankle bracelets, with the 48 hours. I think that's pretty important for people to understand, because that's scary to a lot of people.
Well, there's a provision in the law that when there's an alert that the ankle bracelet has been tampered with, they have to wait 48 hours before they can declare it as an escape. So like, let's make sure he can make the Mexican border. Of course, he'll be going the wrong way.
Oh, they won't try that.
Yeah.
What could we do? Email people, write letters? I mean, where can we go?
Yeah, I mean that, and when people are running for office, anybody that's up for election in November should be pledging that they will vote to repeal this bill. Now, unfortunately, I think timing-wise, there'll be a little bit of a lag, but if it's clear that everybody's coming in looking to do that, hopefully something can be done to stop the implementation. Some people have been trying to kick back the start until July of next year to buy a little more time. I think that's just delaying the inevitable. But again, hopefully I can be successful in what I'm working on right now, and it's going to require, though, the judiciary to do their job too. And we've got good judges in Will County. They set these high bonds, and they're legitimate high bonds based on, it's a balancing test, how violent the offender is. And that's the thing, I forgot to mention the rap sheet on all of these detention things, whether or not they can be detained or not, isn't based on how dangerous they are anymore. It's whether you fit into the little pigeonholes that they put in the statute. So you can have a guy that just gets out of prison for murder and does one of those forcible felonies that's not detainable. He's not detainable. I mean, right now we use common sense and we look, this is a really dangerous guy. We need a higher bond on this than we would normally get. Not going to happen. There is no bond. So, like I said, the U.S. Constitution guarantees it. The Illinois Constitution guarantees it. They don't have the legal authority to do what they did. So,
Who is publicly endorsing this? That's an elected official right now that you know of, or anybody in your position?
well, I'm not sure. Obviously, there's Chicago people, or Chicago elected officials that are doing it. And the irony there is they're slitting their own throats.
Sure.
My God, you unleash the beast up there more than they've already done. I mean, look what just happened in Morris.
Yeah.
Did you see that?
Of all places.
And they have eviscerated my ability to deal with juveniles. They have just cut my hands off. We can't even talk to a juvenile anymore until they get an attorney. You can't, one of the standard tactics of a good detective is, we got your fingerprints all over the murder weapon. Okay, the officer doesn't know that for sure, but he says that just to see where it'll go. Now, we don't trick people into confessions that we can't corroborate. In other words, when someone confesses, we have to corroborate everything that he or she has confessed to with independent evidence. So if the officer is telling something that's fabricated and the guy admits to it and it turns out it's not the case, then it's meaningless. But many times when defendants think you've got them cornered, they'll try and make excuses or rationalize and make up a story, but they'll put enough elements in there. We can't even talk to the juveniles anymore. And this whole concept that they're too young to know what they did. I mean, the savagery of what happened in Morris with the child present. I don't care how old the person is at that point. I mean, the crime is so vile. The person that did that is a very dangerous person to each and every one of us. And to just say, oh, well, the prefrontal cortex hasn't quite formed yet. Okay? That's okay in a lot of crimes, and I'll sit down with anybody. If you want to talk about non-violent property crimes and recog bonds for those kind of cases, we don't need to clog our jails with those people. But there are so many other types of crimes, especially the drug crimes, which are not provided for this time around. those drug dealers that are dealing fentanyl, they're as dangerous as any murderer. Because every time they sell their product, 2 milligrams will kill you. And these young kids that thought they were entrepreneurs, they were selling pills on the internet, and they would put maybe only 1 milligram of fentanyl in each pill, but they didn't warn the people buying it to only take 1 pill. Because if you take 2 or 3, it'll kill you. And so that's been happening all over the place. And China is dumping fentanyl in here at a rate like we've never seen. Yeah. People in Homer Glen have common sense. It's good to be here.
Thank you.
Thank you, Jim.